And welcome to the Week 1 video lecture. In Week 1, we're going to be studying Chapter 1 of our evidence textbook. We will see that the basics of evidence, the things you need to know at the most fundamental level, are going to be covered in this chapter. They will be very important for you to understand, and they will be coming back at you again and again and again throughout the course. So really important to pay attention to this fundamental work with evidence. And let's get right into it. All right, so let's think about evidence. Evidence that is introduced at a trial could be just about anything if we didn't have rules that say some things are not going to come in while others will come in. In essence, some evidence we feel is not sufficiently reliable, not sufficiently good enough to tell the jury what the truth is in a given case, and so will be excluded because it's just so poor in quality that it's highly likely to mislead the jury away from the truth rather than lead them into the truth. If that's the case, then we don't want that kind of evidence put before the jury. So you will see, and if you were in a given case, you actually were there as an audience, and you were able to see, what the jury does not see when they're brought outside the room while the attorneys and the judge are discussing whether a piece of evidence is going to come on before the jury or not. You would see what kind of evidence is being offered, and you'll see whether or not the jury actually gets a chance to see it. And sometimes that evidence that is talked about by the judges, the judge and the jury, or excuse me, the judge and the attorneys, is sometimes not introduced, and the jury never sees it. And of course, if they never see it, they can't consider it, and that's exactly what we want, because we don't want them to see certain evidence. We think that they can't deal with it. We don't think it's good enough. We think it's misleading at best and often false and corrupted, and we don't want to see our system of truth finding being corrupted by things that are that poor in terms of quality. And there's much of that. I want to say that there's only a certain amount of stuff that's going to get into court, and generally speaking, only what we would consider to be generally reliable evidence is going to get into court. However, this process required the courts at first to create rules, because the legislators had not created any rules about what kind of evidence would come into a court. If we took the first day a court was convened back in the time of William the Conqueror, about 1000 AD or so, there was no rules. You could put on anything you wanted. You could put on someone to say, oh, I heard somebody say that such and such happened, so obviously that's what happened, and therefore we should win. That kind of thing. There was nothing to prevent that. And so after a period of time and over much wisdom being placed into watching these trials with this really bad evidence render some very unjust verdicts, that over time the courts started figuring out that certain evidence just cannot be trusted, cannot be used. It's just going to be bad news in terms of truth finding, no matter what. We can't make it better. And that kind of evidence we're going to exclude. And they did that over that process of all that time of basically 1,000 years of English and American jurisprudence, where the courts made up their own rules. And again, the reason why is because the legislature did not make up rules for how evidence was going to be allowed in or not allowed into a trial. And so quite a bit of very good rules were made by courts, honed over the 1,000 years or so of experience with many trials and many unjust verdicts because of bad evidence being brought in. And we started making rules. The judges started making rules. Those rules became what we call common law, because they were sanctioned by higher courts, and they were actually ordered to be used as rules for the lower courts, to a point where they had gotten together a pretty good range of rules about what kind of evidence could come into a court and what kind of evidence could not. But it turned out that the legislatures somewhere along the line, and about 1975 is about the year when this happened, decided that they didn't want the courts to decide what kind of evidence was going to be introduced in a trial. They wanted to be the ones who made that decision. And that often had to do with privileges, which we'll talk about later, which are things where we give people a privilege, for instance, not to disclose certain evidence because we know that certain very important interests are at stake. So, for instance, the attorney-client privilege says we will allow a client to talk to his or her attorney freely, so that they don't have to worry about that talking ever coming back and hitting them in the back of the head at a trial because they essentially spilled the beans to their attorney. And so we have a privilege. You can't get into what was the discussion between the attorney and the client, no matter what, pretty much. And so that's a rule. We give a privilege. Again, the courts had made up that privilege, by the way, because of public policy reasons. But the legislature said, well, we don't want courts making up all these privileges and other rules and so on because there's too much at stake. We don't want our system to be ruled by essentially judges. We want the system to be ruled by legislators who are the ones who should be making the laws rather than judges. And so they sort of took control at some point along the line. So about 1975, and before 1975, in every state and in the federal courts, it was all common law. It was all basically made up by judges, rules that had been honed over that 1,000 years. And then comes 1975, and then the first model code of evidence is proposed and sanctioned by the Congress, our federal Congress, so that now the federal courts for the first time have an evidence code. That means there are statutes that say when evidence can come into a court and when it cannot. And it mandates that judges actually follow the evidence code and not the common law any longer. So now common law has essentially been thrown out, except for there might be a few areas where the legislature didn't actually make laws. And if there are a few of those out there, then there may still be some common law, say privileges out there that are still there. But for the vast majority of all evidence that comes into a court now, as to the federal courts anyway, it is now all based on statutes that are made by Congress on everything in terms of what can come in and what cannot. So what happened was the federal codes that were first put together in 1975 then became the model for the states. And many states, in fact, probably all states now, have enacted their own evidence codes, just for the same reasons why Congress did so for the federal courts. Because it's just too important that they have control over what gets into the courts and not the courts themselves. Because, you know, judges, again, shouldn't be making law according to the legislators. That's the legislator's job, not the judge's job. And so they took it over, and then once the federal courts had their evidence code and was using it, then it became the model for all the other states, including California. California is very, very close to the federal evidence code. That's why we are, in fact, studying the federal evidence code and not California specifically. Because you may not practice, for instance, in California. You may go to another state somewhere, and you may need to know what the evidence code is in that state. Or you may also need to research the law in another state about what its codes are. So you need to have familiarity with the evidence codes generally. But because we study the federal rules of evidence now under the codes, we will pretty well have a pretty good idea what the evidence code is in any given state, because there's quite a bit of uniformity. So don't worry about the fact that we are studying the federal rules in terms of whether you're in a California Superior Court under state law, because you're going to find them to be almost the same. Again, there will be differences, but you will be able to know them because I'm going to point them out as we go through the course. However, very important for this course is that you will follow the federal rules of evidence for all the questions on the quizzes, on the final exam and everything else, unless I specifically ask you to look for another kind of law. And that's because we need to have one law for you to be applying. I don't want you to have to apply, well, let's see, the federal rule is such and such, the state rule is such and such, and apply them, alternatively. And that's a little bit too much for you. So just know that if I don't say otherwise, when I'm talking about whatever law there is about evidence, it's going to be the federal rules of evidence, which are the codes enacted by Congress in 1975. All right, so just realize that, again, there were common law rules before, and they, for the most part, do not exist any longer. Now, another concept that's very important for you to know is that these rules are very much, sort of what we call chiseled in stone. They're basically what we call black letter law. They say that if hearsay is excluded as evidence, then it has a very definite definition for what hearsay is. And therefore, if I were to say, okay, well, I'm going to find a way to get this evidence in. I really like it. It's really good stuff. It's going to be really good for my client. I got to find a way to get it in. It would normally be considered hearsay, but I'm going to modify how I'm going to introduce it in such a way that I'll get that evidence before the jury so they can consider it maybe for the purpose, the wrongful purposes that it shouldn't be considered for. And I hope that that actually, works. And attorneys do this all the time. And you say to yourself, wait a minute, how can we allow a system that just allows attorneys to find a way around these rules and get evidence in? Well, we'll find out that that's not as big a problem as you might think, but what I do want you to know is it is not unethical for an attorney or a paralegal to propose a way to get evidence into a trial where it is excluded under one rule but might be admissible under another. It may be excludable for one purpose but admissible for another. And so what happens is you'll end up getting the evidence in. And then you hope the jury uses it for the best purpose that it can be used, and you win because it's there for them to consider, even if they're told they can only use it for a limited purpose. So that's what happens, is that because we have these set and cement kind of rules, we can work our way around them sometimes by changing aspects of it. So let's just say hearsay very quickly. Hearsay is an out-of-court statement made specifically for proving the truth of what was said in the statement. So if you put in a statement that was made out of court, but it's not put in for the truth of the matter that's stated in the statement itself, then it's not hearsay, and therefore it's not excluded. So you might be able to get it in for a purpose other than the truth. You might be able to get it in to explain why the person did something, that a certain statement was made, and that's why they changed their activities because of that statement being made, rather than the truth of the actual statement itself. But in any event, you'll get the statement into evidence. The jury can consider it, and what you need to know, very much so, is that it is not unethical to do that. We call it backdooring the evidence. We find a back door to get into it. We can't get it in the front door, so we'll go and see if there isn't a back door to get it in. But we want to get it in. We want to get it in front of the jury so they can see it, they can consider it. And so we will find a way, if there is a way, but when we do so, again, it's not unethical. Now, these rules of evidence, you need to know this too, is that they were designed to do justice. That means they were designed for truth finding. Because again, you can't have justice if you don't know what the truth is. You must have truth in order to have justice. And so it is really there to do justice by helping juries to find the truth. That means that only evidence that can help them in that regard, that is evidence that is sufficiently reliable to help them find the truth, is going to be allowed into evidence. And so that's its general purpose, and you need to know that general purpose because that is why it was made in the first place. That's why even the common law had made rules in the past for the same reason. But this one, of course, is very important for you to know, because beyond the fact that it might be on the quiz, it's something that you need to know is its ultimate purpose. It's essentially, it's a filtering system that goes through this evidence that's being introduced. It says, oh, no, you can't bring that in because that's overly prejudicial, or it's not going to be used correctly by the jury, or it'll mislead the jury, or whatever. Or no, yes, you can bring this evidence in because that's good, solid, and generally reliable evidence, so you're going to bring that in. So it basically filters that. As people try to put evidence into a trial, the judge is going to exclude evidence that's not reliable, and it's going to allow in evidence that is reliable. So that a filtering process is what rules of evidence are all about, for the purpose of doing justice as part of the truth-finding aspect of a trial. Okay, now let's look at what evidence is. If we were to define what evidence is, it's actually several kinds of evidence. There's testimony. That means people actually testified what they heard, they saw, what they did, what they felt, what, that sort of thing. There are writings where people have written down certain um, things that have happened, or things that they did, or what other people did, or whatever they're writing down. It can possibly be evidence because it's essentially a crystallized thought or crystallized experience that would otherwise have been testimony if the person who wrote it could come into trial and testify as to what happened, but often that they're not available for that purpose. Then there's material objects. That means things like if you had a murder case, you might want to have the murder weapon. That's a piece of physical evidence. It's a material object to show the jury, oh, here's the murder weapon, and here's how we know it's the murder weapon. Here's how it all happened. It's a way of showing the truth about what happened, is actually to bring in these items there that were part of the incident that brought the entire matter to trial in the first place. And they could be other things too. It could be just about anything that's going to be presented to the senses, and that can prove the existence or non-existence of any fact necessary to be proved in the case. And the reason why there's that catch-all language of any other thing that presented to the senses that is offered to prove the existence or non-existence of a fact is because there just probably isn't any end to what evidence can be. In some cases, some of which you'll see in our discussions, we brought in a dog into the classroom, into the courtroom, excuse me. And the dog became what we call demonstrative evidence. It was actually a service dog. And to prove that he was actually a service dog, he was brought in, and we showed that he was actually doing his job right there in court so the jury could see him. That's evidence. It's not evidence that you could put a tag on and put back in the jury room, but it is demonstrating to the jury that the dog was actually doing something they were trained to do. All right, so let's look at witnesses. There's two different kinds of witnesses, because testimony, of course, is a big aspect of just about any trial, as you know. You go into a trial and you watch a trial in any of the courts over there, the first thing that's going to happen, some witness is going to get up there and start talking. And so they're going to testify. They're going to testify under oath, under penalty of perjury. But there's two different kinds. First are what we call lay witnesses. These are witnesses who don't have any particular expertise in any particular area that they're going to testify to. They may have an expertise, but they're not going to testify to it. They're simply going to testify to what they heard, what they saw, what they felt, what may have happened that was within their experience. Anything that they can experience and recollect and relate to the jury will be something that a lay witness will be testifying to, whatever it may be. It could be they were a victim of a robbery and someone pulled a gun on them and they were able to see who it was. They're going to come and testify, and they're going to identify who the person was, who did it, and what they did. That's a lay witness. Now, the second kind of witness is an expert witness. An expert witness does not testify necessarily as a lay witness, although they can. An expert witness is testifying to evidence that has already been introduced in the case, and then they analyze that evidence in some fashion with some expertise in certain areas that they have, and then they render an opinion about something that's important in the case. Let me give you an example. Let's assume we have an auto accident case. A big pileup, 20 cars are piled up on the freeway. And we think it was the last car in the pileup that actually, no, excuse me, maybe it's the first car in the pileup that caused the accident. But it's not exactly easy to prove that. Maybe some of the people who were hurt in the accident really don't recall how it happened because they were hit in the head, and they don't recall very much about what happened since they left, their house that day, because being hit in the head can make it so you can't remember things. So now we got to prove how the accident happened in order to prove that someone was negligent. Somehow someone did something wrong that caused that pileup to happen, or we're not going to get any recovery from anybody. Well, what we would do is we bring in an accident reconstruction expert. That person would go out and find all the data that they could find on the accident. They would go to the police reports. They would go to the witnesses who were interviewed, and they'd pick up all this information about what everyone said, what diagrams were written, what kind of photographs may have been taken. And they examine all this evidence. And they have expertise in physics of motion and so on, and they know how much or how long it takes for a car to stop when it's going a certain speed, even different kinds of cars, how long it takes them to stop, that kind of thing. And then they will render an opinion. Oh yes, I think that it was the first car in this pileup. What they did is they slammed on their brakes, skidded into the other opposite lanes, and caused a pileup in those lanes. You know, that kind of thing. So they can actually determine, at least in their own opinion, what may have happened, so that the jury has a better idea of what all this evidence is that's out there that they couldn't make sense of because they don't have the expertise. So experts are very good to help the jury to put together lots of evidence in a scientific way, and actually then help them to understand the significance of all that evidence. All right, so we have two different kinds of witnesses. So let me give you an example that'll sort of give you a better idea what this definition is all about. A medical doctor might very well testify as an expert in a given case because they have an expertise in medical science. And if they were called upon to be an expert and they had examined the case and they had an opinion, they could testify to it. But a doctor may also come on and testify that they were at the scene of a convenience store robbery and they saw the person who did the robbery. Well, if a doctor comes in and testifies, I saw who did the robbery, and he's sitting right there at the defendant's table, well, then he's not testifying as an expert. He's testifying as a lay witness because he's not using any expertise in his testimony, and therefore he's just an ordinary lay witness, even if he may be a medical doctor. So you could be an expert, but not necessarily testify as an expert witness. And by the way, doctors hate it when I call them as lay witnesses because they can't get their expert witness fees of $2,500 an hour, and they have to be satisfied with $35 a day and 12 cents a mile both ways. And so you can see the difference between those two kinds of witnesses. All right, let's look at exhibits. Exhibits are things that we are physical objects, and in order for us to introduce them, we first have to have them tagged by the court clerk to make sure that it's identified and it's listed out that we actually have this thing down as an exhibit, and then we can possibly introduce them as evidence once we have them marked. But these exhibits could be documents, could be any kind of writing, could be something as old as a 100-year-old Bible that has people's their own family tree in it, for instance, is a very good example of how we sometimes prove who was related to who. Is actually an old Bible can actually be used. We'll see that later on in our studies. All right, physical objects, if they have anything to do with the case, physical objects can be evidence. So if you have a DUI case and they took a blood sample that was analyzed for alcohol, well, you're probably going to see that blood sample as a physical object in the trial, and it has a little it's sealed, and it's got a little wrapper on it that has all sorts of writing on it that says where the thing came from and when it was taken and that sort of stuff. So that could be a physical object. Then there's what we call demonstrative evidence, which is a different kind altogether. It's not one that's specifically related to the case, but it can be helpful to the jury. So let me give you an example. Let's assume we have a murder case, and the trajectory of the bullet that hits the person and kills them is very important. What angle did this thing enter from, and what angle did it exit the body from, for instance? Well, the way we would use demonstrative evidence there is we go get a mannequin, just an ordinary mannequin. We make sure it's male or female so that it looks like the person who died a little bit. And then we would drill a hole through this mannequin in the exact angle that we found the bullet, the trajectory of the bullet to have been go through the body of the actual victim. And then we put this rod through the mannequin to show the jury exactly what angle that was. Now that could be very important because maybe the person who says or the person who's the defendant in the murder case may say, well, no, we were fighting over a gun and the gun went off. That's what happened. I didn't murder this person. It was all an accident. Well, that's interesting. Maybe the angle of the bullet coming from the top of the head down was a little bit much in terms of being able to explain that defense very well. And so that could help the jury to understand that the defendant's lying about what happened. They really did murder this person, but they tried to make up a an accident defense. So mannequins, maps, charts can definitely be demonstrative evidence. In the case of the service dog, as I talked about just a few seconds ago, that dog was demonstrative evidence. It was not something that was marked as an exhibit, put into evidence, and so they have this dog sitting back in the jury room so they can see it. No. It's actually was there in the courtroom and basically demonstrated what he was doing, what he would normally do, and that is to watch over his owner, make sure that the owner was taken care of in some fashion. And so that becomes demonstrative evidence because it's not something we're going to put into evidence, but it is something that helps the jury to understand better, what is really going on in the real world in this case. So if it's something that's not directly related to the case, such as the murder weapon, but can help the jury to understand the case better, then we're calling it demonstrative evidence. All right, there's also another form of evidence, and this one's a good one. I like it if we have it because then I don't have to worry about it anymore. It's called stipulations. A stipulation simply means an agreement. When two parties to a lawsuit or a criminal case agree that a certain fact is true or that a certain fact is not true, whatever the case may be, then that fact or absence of that fact is conclusively proven between those parties. No one can ever contradict it, no matter what. And so it sometimes happens that the parties will enter into stipulations because, first of all, they don't dispute the issue. There's no reason to dispute it. In fact, it may work for the benefit of both parties. And they all want to agree that it's true, and also reduce the time for trial because otherwise they'd have to bring in witnesses to prove it was true. Now all they have to do is enter into a stipulation, announce the stipulation to the jury, put it on the record, and now you have a stipulation. The judge will tell the jury, well, the parties now have stipulated that a certain fact is true. You will consider that to be conclusively proven, and you will not allow anything in this trial to contradict it. That's exactly what will happen if you have a stipulation. Also, judicial notice is another one. It's more rarely used, but it does happen. There are certain incontrovertible facts out there in the world that you don't have to go out and prove. So, for instance, if one of the issues in the case is what day of the week was the 26th of September in 2014, well, you could go get someone to, who's an expert in calendars and bring them in and have them go calculate exactly what day that was. Or you can say, Judge, why don't you go get your calendar and take judicial notice of the fact that the 26th of September in 2014 was on a Wednesday. I'm not sure actually whether it really was on a Wednesday or not, but if the judge says, "Oh, I look at my calendar and there it is," sure, that's incontrovertible. We're not going to allow anyone to controvert that, and it's one of those things that is so incontrovertible that no one can really object to it. It's things like the sun rises every morning. That's kind of one of those things that's incontrovertible, and you don't have to worry about it. It could even be what phase the moon was on a particular day. That's something you can go to an almanac and find out, and they're very, very accurate. So there's really no way to controvert that. But you don't have to go out and prove it. It would be kind of difficult to prove, and it would be very costly to prove, and it's not controvertible anyway. There isn't anyone can say that it didn't happen. The moon has a certain cycle, and it goes every 28 days, and it's been that way for the last 500 million years. It's going to be that way for the next 500 million years. So not controvertible. So it's possible that when you have a situation such as one of those incontrovertible facts, you could say, Judge, would you please take judicial notice of the fact that the day of the week for September 26, 2014 was a Wednesday? Judge would go to his calendars. Oh, yes, you know what? I'm taking judicial notice that that's the case. And then he will instruct the jury that I'm taking judicial notice of the fact that the 26th of September 2014 was on a Wednesday, and I'm going to have you that's conclusively proven. You will not you will not allow any evidence that comes up in this court to contradict it. So essentially, it's an established fact. Nothing can make it go away, or take it on. It is conclusively proven, done. So that's another form of evidence, and it does happen in cases. So you'll see that happening every once in a while. All right, let's look at the federal rules of evidence. Again, like I said before, the federal rules of evidence are similar to the California rules of evidence because the California rules of evidence were modeled on the federal rules of evidence. And except for a few areas where they differ, they are almost identical. Also, what you need to know is there was an advisory committee that proposed the first rules of evidence, and they wrote up some reasons why the evidence code was written the way it was in order to try to help people to interpret what the language really means. And those advisory notes are actually in the statute itself, and they can be looked at for trying to figure out what the rules mean when it's in doubt. There's also advisory notes. Those are comments that accompany the proposals. Those are also available for that same purpose. And so what its purpose was is going to be well established by what the advisory committee says in terms of its actual statements that are in the statute itself, and then its notes that were appended to the statutes as well. All right, let's look at what kind of types of exhibits we have. Remember that we had several different kinds of evidence. We had testimony, we have exhibits, which are typically physical objects of some sort, and then we have demonstrative evidence, that sort of stuff. But let's look at exhibits particularly. First is what we call real evidence, and then there's demonstrative evidence, and there's documentary evidence. Let's look at each of those. Oops. Okay. Real evidence is simply physical objects. We call it real evidence because you can hold it in your hand and you can put a tag on it. As you see so often in these trials, there's, if you have a murder weapon, there's a little tag that says Exhibit 26 on it. That's to mark it so we know which item it is. We've logged it down to make sure that we keep a record of everything that's been introduced at the trial. But it's in physical form of some sort. Now it may be an electronic file, electronic document, but it's still considered real evidence in that sense if it's a document. But real evidence is something physical. That's where you look at real evidence. Demonstrative evidence is what we talked about before, and that's where it's not something that's directly related to the case. It's not something that came directly out of the case or is direct evidence in the case, but it is something that could help the jury to understand the case better in some fashion. It can be a chart, a compilation of information, a map, a drawing that someone makes while they're testifying can be demonstrative evidence. The service dog was another one, as we saw, that kind of thing. So demonstrative evidence is just one that we, it's the mannequin. That's why I always think about it, demonstrative. It's the mannequin that has the holes in it, for the bullet trajectories and that sort of thing. It's just a way of sort of demonstrating what all the evidence really means, rather than itself being a piece of evidence. All right, documentary evidence is simply writings of any kind. Writings can be considered actually people where they actually write something down. It can be voice recordings. It can be video recordings. It can be anywhere. When information is written down or put in some physical fixed form in some fashion, that's documentary evidence. So it includes photographs, videos, audio tapes, actual writings, all electronic writings of all kinds. Even if created by a computer, they're still considered a document. We'll see that some of those are admissible as evidence and some are not. And we get into the exceptions to the hearsay rule. And so this is the three different kinds of exhibits. All right, let's look at also the different kinds of evidence. There's two different kinds. Direct evidence and circumstantial evidence. There's only two different kinds, actually, in that sense, in terms of what kind of evidence, whatever it is that we're introducing, might be categorized. Another way of saying is categories of evidence are direct and circumstantial. Now, some of you may have heard statements, almost cliches at this point. You can't prove a case by circumstantial evidence, and that kind of thing. We can't prove a case because no one saw the person murder the person. No, not true. Direct evidence means it's evidence that if it's introduced, it doesn't need anything more to prove whatever it says. So, for instance, if we have a victim of a robbery and they come in and they testify, yes, I was the victim of the robbery. Yes, a man pointed a gun right in my face and made me take out everything out of the cash register and give it to him. And and they ask, well, is that person in the courtroom today? And the person says, oh yeah, it's sitting over there at the defense chair. Well, that's direct evidence, meaning we don't need anything else, any other evidence that's necessary to prove that the defendant in fact robbed that person. But now let's get you another situation. there's a robbery, but the victim, unfortunately, was killed during the robbery, so they can't testify. Well, somebody in the store heard a man, screaming, give me your money or your life, and then heard a gunshot, and then heard a man running out. He goes outside to see who ran out of the store, and he sees the defendant running out into a car, getting in the car and driving away. Well, that's not what we call direct evidence that the defendant committed the robbery, but it's pretty close. But it's not. Because why? Because it needs what we call an inference in order to make it to the conclusion that the defendant did the robbery. The inference is if someone is heard screaming, we hear a gunshot, we know later that the victim of an apparent robbery was killed as a result of a gunshot, and in close proximity to the gunshot, a man is seen running out of the store where the robbery took place, and that person is the defendant, then by logical inference, the defendant is the one who committed the robbery and the murder. But it's not direct evidence because it needs us to say, when you have all this stuff, such as the gunshot, the screaming, the running out of the convenience store in direct proximity to the gunshot going off, then most likely the person who was running out of the place was the person who did the robbery. That logical inference is necessary before we can use the evidence. And so that's actually circumstantial evidence. What the witness saw was circumstantial evidence, not direct evidence of the crime. And so that's why we call it circumstantial, because it requires an inference. I mean, it's a set of circumstances that, together with a logical inference from those circumstances, would prove what we're trying to prove. But direct evidence doesn't need anything like that. It's you robbed me, you're the guy, and I saw you do it because I was there and I'm the victim. That's all you would need to prove it, because there's no inference necessary. Now, direct evidence is the typical eyewitness testimony. It means they saw the whole thing happening, and they can testify to what happened, and you don't need anything more than that one witness, because there's nothing else necessary if we believe the witness is telling the truth. But circumstantial evidence needs lots of circumstances, and then a logical inference from that to get to the conclusion that we're looking for. Okay. Now, there's lots of different examples of direct and circumstantial evidence, and I've got a website here for you to look at that I think you should probably go look at, because I think it'll give you some good circumstances about whether something is direct or circumstantial evidence. But what's very important about these two different kinds of evidence is that no one of them is better than the other, and I want you to know that. That's contrary to what you may have heard, such as the old Perry Mason TV show. I'm not sure many of you had seen that, but you may have seen it in reruns. It's probably now 40, 50, 60 years old now, but it was a very famous saying. It's just a circumstantial evidence case. You can't prove it you can't prove a circumstantial evidence case. He kept saying that all the time. He was a defense attorney in a criminal cases. He was very good at what he did, but what he said was really stupid, because it's not true at all. In fact, there's a lot of good evidence out there that that eyewitnesses are very, very unreliable for a lot of reasons. Not because they're lying either, by the way. It's because what they see is often not the person that is the one who did the crime. Especially when they had never had seen that person before. If you never seen someone before, and then you see them in a crime, especially if you're the victim, all sorts of reasons start showing up as to why you will most possibly misidentify someone, and then someone is possibly convicted on the basis of testimony that you did quite innocently, but wrongfully, not wrongfully, but falsely, because it wasn't true. And now circumstantial evidence is less likely for that to happen, because, first of all, circumstantial evidence often comes from many different sources. For instance, I used to have cases when I was a prosecutor where I'd get evidence from the sheriff, I'd get evidence from one of the police departments, I'd get evidence from citizens, and when I put all these circumstances together, they would all lead to the same result, and they were all pointing in the same direction. very unlikely that evidence is pointing us in the wrong direction, because everything's pointing in the right direction, and it's coming from many different sources. So the chances of it being biased or falsified or tampered with, that sort of thing, is really very low. With direct evidence, it doesn't even have to be that someone wants to try and convict somebody wrongfully in order for it to be bad, because just very often we find that eyewitnesses don't do a very good job. And we know there's many different reasons why. We know why, but there's lots of different reasons why. And so direct evidence cannot necessarily be so good. Of course, the best thing in the world is to have both direct evidence and circumstantial evidence in a case, because then, if what the victim says happened and they saw what happened, and all the circumstantial evidence points towards that's what happened, then you have a pretty good case. But you can have a perfectly good, completely circumstantial evidence case. For instance, the O.J. Simpson murder trial was entirely circumstantial evidence. Now, it didn't turn out to be very good for the prosecution, but it was entirely circumstantial. There was no witness that saw who murdered the two victims. There wasn't a single witness anywhere. And so no one could be testifying as to direct evidence in that case, no matter what. And a vast majority of cases are proved, and even criminal cases are proved circumstantially, not by direct evidence. All right, so look at those different examples that you find on the indication that I give you at the encyclopedia.com. It's a good place to go look for that. All right, let's look at some other aspects of evidence that you need to know about. One is what we call discovery. Discovery is a legal process. By legal meaning it gives rights to parties who are in a lawsuit, whether in a criminal lawsuit or a civil lawsuit. It gives them rights to collect evidence either from the other side or from third parties not even related to the case, forcibly. That means through the compulsion of law to make people give them things. Give them evidence of all kinds, including testimony, even before the trial. This discovery process is, again, a legal process. It's basically like it's a toolbox. There's lots of tools that can be used by different parties, depending upon whether it's a civil or criminal case, because discovery rights in criminal cases are a little bit more limited than they are in civil. But civil discovery is full of different mechanisms to find evidence. You can, in the discovery under a civil case, require your opposing party to come to a deposition and testify well before trial on all aspects of the case, simply by sending them a notice saying you're coming down to a deposition. We're going to put you in front of a notary public, and you're going to testify under oath, and you're going to tell us what we want to hear. Or you're going to tell us you're going to answer our questions, essentially, whether you like it or not. If you refuse to do so in a civil case, one or two of these things will happen. If you're the plaintiff and that happens, you're going to have your case dismissed. If you're a defendant and that happens, you're going to get a default judgment imposed against you. You lost, essentially, because you wouldn't go through the discovery process. In a criminal case, the prosecution must give all the evidence it's going to produce at trial, and must also give any potentially exculpatory evidence to the defendant by operation of law and through constitutional requirements. Have to give it. And there's many states that require the defense to give discovery of certain information that they have also. The discovery process is not only a process by which we allow the parties themselves to go collect evidence so they can prove their case at trial, but it's also a good technique for settling cases, because once you've sort of collected all the evidence, you've got it all together, and the trial's coming up now, you then know what's going to happen at trial. Often you know what you can prove, you know what you can't prove, you know what's good about your case, you know what's not so good about your case. And so it fosters settlement. Now, it is this discovery process where people involuntarily can extract evidence either from the other side or from third parties that make the discovery process really an evidence collecting process in both criminal and civil cases. That's what I want you to know about discovery. It's a very important aspect of evidence because you'll find out in civil cases, for instance, it's not unusual for 90% of the lawyer's fees and paralegal fees to be spent collecting evidence on the case through this discovery process. because you only suspect someone did you wrong somehow, and you got to go out and prove it. So you got to start collecting evidence that says that that's what happened, and so it can be very expensive. All right, so let's look at some of the tools that are available to compel others to reveal evidence, both in criminal and civil. First, there's a subpoena. A subpoena is a court order that orders a person to come into a proceeding of some sort, some official proceeding, and testify. A violation of a subpoena will put somebody in jail. You don't come in, we send out the marshal to go pick you up in handcuffs, and you're coming in, you're going to testify anyway. It's that kind of a thing. It's just, this is a court order. You do not violate a court order. So you talk about compulsion, there's compulsion, all right. Subpoena ducis tecum is simply a Latin phrase. Subpoena ducis tecum means a subpoena for record. So it's not only does you have to bring in someone to testify, but they have to bring in certain records with them. These subpoena ducis tecums are used for third-party, usually businesses that have records of a certain thing that we want to bring into the trial. So I may want to subpoena telephone records of the defendant. I got to go send a subpoena ducis tecum to the telephone company and say, bring in these records for this guy and come in and testify that they're authentic and that they meet the requirements of the hearsay rule, so we can introduce them as evidence, and so I can prove what calls he made on a certain time or what calls he was receiving on a certain time. All right, deposition. That you'll see also in both criminal and civil. Both subpoena ducis tecum are in both civil and criminal, and the deposition is also used in both civil and criminal, although very rarely in criminal. There's lots of requirements in order to have a deposition in criminal, so you're not likely to see it as often, but they do have rights to depositions. A deposition is simply where you bring in a witness via a subpoena, or if it's a party, you simply notify them, tell them, you're coming on into a deposition, and it usually is done in an informal setting unless it's in a criminal case, because criminal cases you actually have to go into court. There has to be a judge there, and the person has to go to the witness box and testify with both parties there who can examine and cross-examine the witness back and forth until they don't have any more questions. Just the same as if they were in a trial. And so you get sort of a foreknowledge of what this person can say before the trial actually happens. And again, you can do that in both criminal and civil. And it also preserves the person's testimony, because since both sides had a chance to examine and cross-examine the witness, then that evidence now is admissible in trial, as if the person had testified, even if perhaps they die before they get on the stand. We could just put on their deposition, and that's their candid testimony, and it's just as good as if they had testified in front of the jury. But it's used as a discovery technique, so we can discover what that person can say or is willing to say before the trial. Okay. Now, orders of examination. These could be done in criminal, but very rarely it can happen. But typically they're done in civil. These orders of examination are where we have a certain person who has put their physical injuries into issue. So you have an auto accident, you got hurt. You say, I got hurt and I couldn't go to work. The other side says, well, I don't think you were hurt that bad. Let's have a doctor examine you, because I don't necessarily believe that you're telling me the truth about your injuries. Either they weren't as bad as you say they are, or maybe you didn't have any injuries at all. And so you ask the court for an order to have that person examined by a doctor. And the person really can't refuse, because if they're asking the court, to impose judgment against the other side based on these injuries, he can't hide them. He has to make them available to the other side, because that's only fair, so they can get a chance to see if they're telling the truth or not. Then there's a request to produce documents. This is only in civil. This allows one side to request the other side to give them documents that the other side has. This is only between parties. This is not something you would send to a third party. If you want documents from a third party, either in civil or in criminal, you send a subpoena ducis tecum, which is a court order to order them to come in and bring in the documents. But if it's to a party, then you can simply request them to produce the documents, and it's not really a request, because there's legal compulsions to make them do it. So although we may say, please give us these documents, in reality, we demand you give us those documents. And if you don't, we're going to ask the court to sanction you for not doing so. There's legal compulsions. You must do it, or bad consequences are going to happen to you. There's also disclosure requests. These come in the criminal cases, Disclosure request is like a defense attorney in a criminal case would say, please give me all this evidence that you have about this whatever. And it may be something that the prosecution hasn't already given them, but didn't realize they should have to give it because they didn't think it was relevant. For instance, the notes of the examiner who does the blood test. Well, that's not usually something that the prosecutor would give the other side because it doesn't seem to be relevant. There's nothing in the notes that would say that the blood wasn't as he said it was, but they want the notes. Okay, fine. You want the notes? Give me a disclosure request and I will give you the notes, okay? So that kind of thing. All right, motions to compel production of documents. That means if we make a request to produce documents from the other side and they refuse, then we go to court. We make what's called a motion. A motion is where we ask the court for an order. Because especially in civil cases, the court is not there when the parties are exchanging information. But there's still legal compulsions to make them disclose it. But what happens if one of them says, I'm not going to do it? Well, then the only alternative you have is to go to the court and say, court, will you please order him to do it? The law says it's mine, and make him do it. And so you file what's called a motion. And the motion is simply a request for an order. So when the discovery process sort of gets a little bit of a hiccup in it because someone's not doing what they should, then the court will order them to do it. If they don't do it then, they're going to go to jail. And they may have sanctions in the case too. They may, for instance, if they're the defendant and they're not giving evidence, they can have their default judgment set against them. So they will essentially have lost because they didn't cooperate with the discovery rules and the requirements that they have to do, simply have to do. If they don't do it, then they're going to lose. We're not going to play any games with people. If they don't want to meet their legal requirements, they're not going to get a forum to hear their defense. That's the end of the story. All right, requests for admissions and denials. That's request for admissions is only in civil. It's where we're sort of at the end of the discovery period, and we sort of have a pretty good idea out there of what kind of facts and circumstances both parties agree to, because when we've asked them questions before, they've given us certain answers, and we sort of figure out that there's maybe 50% of the case is really not controversy. And so they will request for them to admit certain facts and to admit certain documents are authentic so that we don't have to go and prove them up at trial when there really isn't any controversial nature to them. And often they will admit them, but if they don't, and it looks like it's a wrongful attempt to harass the other side, then they'll get sanctioned by the court for not having admitted them when they should have. Next is interrogatories. These are only in civil. These are written questions from one side to the other side. It is not something you can do to a third party. It's only something you can do to another party in the action. But you can ask them written questions, and they have to answer them under oath. And so long as they are legitimate questions, then they have to completely answer them. Failure to do so will subject them to the same kind of sanctions I talked about before through our motions for compelling documents and so on. All right, let's look at how evidence is obtained. As you might imagine, in many cases, we would hope that we can interview witnesses rather than sending them to a deposition involuntarily. We hope that they would be cooperative and tell us what they know. And often, if they are really not on one side or the other, they will cooperate because it may be a couple of minutes of their time, and it's better than having a subpoena dropped at their door and say you're coming in whether you like it or not during some very inconvenient period of time. But depositions are also very expensive. You could spend $1,000 or $2,000 a day just in attorney's time and time for the reporter and so on. You don't want to have to do that unless you have to. So you'll try to interview them. That means a voluntary interview. That means when you're interviewing and there's no law compelling people to talk to you, they don't have to talk to you. So you make them want to talk to you by being nice, and you just hope that they'll talk to you. And if they do, then you'll interview them. You will put down what they have had to say. And then, at the proper time, you'll subpoena them for trial if they have important testimony for the trial. And that's one way of collecting evidence. It's a very good way, and it's often the most valuable way. You see police officers out there doing that all the time. There's a robbery out there. They're out interviewing every witness they can find. And they're writing down everything they have to say. And they put those in reports. The reports go to the prosecutor. And if it's a good enough case, they take it. And then it goes to trial. Also, you can collect physical evidence. Let's say there was a murder case, like the O.J. Simpson case. They were out there for a very long period of time collecting evidence of all kinds. They didn't do a particularly good job of it, as we will see later on in our course. But they were out there at the scene of the murder, and they were collecting lots and lots and lots of evidence. Then you can also get experts to evaluate evidence that requires some sort of expertise to understand. Really, expertise does not mean you have to have a doctorate degree in order to have expertise. I remember one very good case where a man who was a contractor, he's been a contractor for about 30 years in a particular industry, heavy construction work, and he was a foreperson, and he was very good at what he did, and he knew how certain machineries operated. This machinery happened to have gotten in an accident, killed one of the people who was operating it, and so they called this person to ask if he could analyze how this accident happened, because this particular machine was not used by a lot of companies, and he's one that had a lot of experience with that particular machine, day in and day out. He sort of knew how it happened and how it worked and everything else. So he was the best person, and that person didn't have a degree of any kind. Doesn't need a degree. He had 30 years of experience with that particular machine. That's more than good enough to be an expert. The next is we will subpoena in the witnesses that hopefully we've interviewed, but some of them we may have to take depositions because they don't want to talk to us. We take their depositions. If the depositions give us, indication that we want to bring in the testimony that they have to trial, we're going to subpoena them to trial. They're going to have to come in and testify. Subpoena duces tecum if we have people that are outside of the case itself, third parties who have documents that might be relevant to our case. We're going to give them a subpoena duces tecum. We're going to say, bring in your records. All right, deposition is another one, of course, where that's an informal testimonial event, but it's one that is just the same as if it were in trial. It can be used as if it were testimony if the person is no longer available. It's under oath, under penalty of perjury. All the parties to the case are in attendance, can examine and cross-examine the witness, just the same as if they were in trial, whether it's civil or criminal. It again operates as testimony. And again, this is one where if we thought the person was not particularly cooperative, or certainly if they're the opposing party, we're going to want to depose them rather than just informally interview them. Because in an informal interview, there's no obligation to tell the truth. And so we don't let people who we think might not be telling the truth get away with talking to us without being under oath. So they have at least some warning that they better be telling the truth, even if perhaps they don't. All right, orders of examination, we talked about that before. That's physical and mental examinations that were ordered by a court as a discovery device. That means where a person's injuries, either physical or mental, have been brought into issue in some way in the case, and a person's asking for either justice because it's a criminal case for the injuries, or for damages because it's a civil case, then the court can order a physical examination of the person who is claiming those injuries. Request to produce documents, that's simply the same as a subpoena duces tecum, but it's to a party to the action. It has the same effect as a subpoena. Disclosure request, that's demand for documents and things in a criminal case by the defense or the prosecution. Either side can actually make the disclosure request. And then, of course, a motion to compel, which could be for both production of documents, or it could be a motion to compel someone to a deposition, or motion to compel them to answer their interrogatories. Those are things that simply ask the court to order them because they had not been doing so in the past on their own voluntarily. All right, let's look at interviewing witnesses. It's kind of important in interviewing witnesses. We want to use what are called direct questions in our interviews. The reason for that is that an interview is something that is voluntary. A person can, at any time, get up and walk out the door and never talk to us again, except maybe if we subpoena them and they have to come into trial. But we want them to talk to us. We want to be nice to them. We want to. We also don't want to. We don't want to influence what they have to say. We really do want to know the truth, and so we don't want to ask questions in such a way that might suggest to them what the truth is. Direct questioning is where we say, "Okay, where were you on such and such day?" Okay, you were at the convenience store. Did anything unusual happen at that convenience store? Oh yes, there was a robbery that happened. Okay, thank you very much. It gives them a chance to answer without us having suggested the answer to the question. That's opposed to what's called our leading questions. If I were asking the same witness, isn't it true that you were at the convenience store on such and such a day, and by the way, you witnessed a robbery in which the defendant robbed this victim, this poor little lady over here. Isn't that true? That's a leading question. Now, leading questions are not good for two reasons. One is they sometimes can be accusatory to the witness themselves, and therefore they may want to get up and walk out, which defeats our purpose. But it also suggests to the witness what the answer should be. You don't want to do that if you want to know the truth. Don't do that, because people will sometimes pick up on the fact that, oh, I guess he wants me to say this, so I guess I'll say that. That's not what we want. We really want to know the truth, not what we suggest the truth should be. I'll give you an example of that. I had a case, it was a 3-strike case. It was kind of big. There was a guy who was, he was a resident in a house, but there were like 25 other people that lived in that house. And there were 3 or 4 or 5 guys who were living in one bedroom. He was one of them. And the narcotics officers broke in on a search warrant one day because it was a drug house. And this defendant, booked out the window in his underwear because it was the middle of the morning. People hadn't gotten up yet. Cops were breaking in. So he books out the window, runs away, and then knocks on one of the apartment doors. Someone opens the door, and he runs in there, and he basically kidnaps the person on the inside. And you have a real difficult situation at that point. But what the real issue was that there was a pair of shorts on the floor that had a gun in it, a loaded gun. And it was very difficult, since there were like 3 or 4 other guys who lived in that same bedroom, as to whose shorts they were and whose gun it was. But this is a guy who had a number of felony convictions, so that possession of a weapon by a felon was another felony, and he was going to get 25 years to life if we could prove the case, and nothing if we couldn't. And so I just had a sneaking feeling that the person that he had kidnapped in that apartment, who later, by the way, he released, and cops came and picked him up, and there was no problem eventually. But I'm sure the person who was in his apartment who opened that door wished he hadn't. But this guy's in the room, not letting this poor guy leave that opened the door, and he's pacing back and forth, and I assumed that he probably said something. And so I asked this person whose apartment was basically robbed that morning, did this person say anything while he was there and pacing back and forth on your carpet? And he said, oh yeah, he did. And I said, okay. Well, see, I didn't want to influence this witness that maybe he was talking about a gun. So I said, did he say anything about a firearm? So the word firearm is a generic term. It could be gun, meaning handgun, or it could be a rifle. And so I wasn't suggesting anything other than, did he talk about a firearm? And of course, this guy said, oh yeah. He said, they're going to find the gun in those shorts, and I know that they're going to think it's mine. I thought, oh wow, beautiful. Here he is confessing to the guy in the apartment that gun was his. Well, that did him in. But if I had asked a question such as, didn't he tell you about the gun that was in the shorts? That person might have said, oh yeah, without realizing it, that I was influencing him. You don't want to do that. So you never want to use leading questions in an interview. You want to use direct questions. These are questions that are designed to let the witness tell you what happened, not suggest to them what happened. Okay, so leading questions you want to avoid. And of course, if they're accusatory to the person who you're interviewing, they will just walk out the door. So you're going to defeat your purpose by using it for that reason anyway. All right, so let's look at what paralegal duties are in terms of evidence. First, evidence collection. You will do a lot of witness interviews. Document collection. You'll create demonstrative evidence like charts, maps, all sorts of things. Even PowerPoint presentations might be considered demonstrative evidence. You're going to research the law to ascertain if the evidence is admissible or inadmissible. You're going to making up maybe drafts of motions in limine, which we'll talk about what those are, that have to do with asking the court to make a ruling on whether certain evidence is admissible before the trial. And you're going to write memorandum of law to the court on this drafts of it, at least for your supervising attorney. So you have lots of good things to do there. You're going to also probably be involved in requests for admissions, the civil discovery device that requests the other side to admit facts and authenticity of documents. You're going to be involved in those. You're going to be involved in the entire discovery process, for that matter. Interrogatories, of course, are another civil discovery device we talked about before also. Let's look at the procedures for how to deal with evidence. First of all, when evidence is introduced, it means what happens is someone asks a question of a witness that calls for a certain kind of answer. Well, the law is really clear on this. If there's no objection to that question being asked before the answer is given, then for the most part that answer is allowed in and the jury hears it, and there's no way you're going to be able to prevent it. In essence, if you don't object to evidence being introduced, it will come in regardless. I've had several cases where I brought on evidence as a prosecutor in cases where I was just waiting for the objection, waiting for it. Why aren't they objecting? You know, I asked the question just to see what would happen, and no objection, and the evidence came on, and I thought, wow, this guy's asleep. This defense attorney's got to be asleep or dead. I'm not sure which one. And I asked another one with a very objectionable question, and they wouldn't object. And again, I think they were asleep because it didn't do their case any good. They lost the case probably because of it. It does happen from time to time, or they just didn't do their job, essentially. The job is they have to object to evidence coming on at the time it's being introduced, or they will be forever have waived that objection. I mean, forever. You can never get it back. Once it's done, it's done. You have to object first. Now, what could happen also is what we call pro-offered evidence or proffered evidence. What this is a process where you ask a question. Let's assume you ask a question of a witness that would call for what looks like hearsay evidence. And hearsay is inadmissible evidence. We'll see that later on in the course. And then the defense attorney objects. Judge, that question is eliciting hearsay, and I object. It's inadmissible. And the court says, yes, Mr. Prosecutor, why should I allow that evidence on? And then what has to happen is you have to offer or pro-offer evidence to show why that evidence that appears to be a hearsay statement that you're asking for should come on as evidence. Okay? It could be the pro-offered evidence might be some additional evidence that you're going to put on later that would be necessary to prove in order to put that evidence on. And you then make an offer of evidence. Say, Judge, I will prove the underlying foundational facts that I need to prove to show that this is admissible. And the judge will say, okay, I'll tell you what, I'm going to let this evidence in now. But if you fail to do so later on, I'm going to not only sanction you, I'm going to get a mistrial, and we're going to do this case all over again. Okay, so you better, when you offer that evidence, you better have the evidence, or you're in big trouble as an attorney. So it's called pro-offered evidence. If you've got an objection, and the only way to overcome that objection is to offer an additional evidence as to why it is that that evidence should be allowed on, because perhaps there's certain foundational facts you need to prove up, then you'll have to offer that you're going to prove those up and tell the judge how you're going to do it, so that the judge feels secure that they can let that evidence in now, because there will be sufficient evidence later on that will make it admissible. Okay, so that's proffered evidence or pro-offered evidence. And then it's in the face of an objection for what looks like inadmissible evidence, but perhaps is not. All right, motions in limine is another way that we deal with evidence. A motion in limine is simply a motion that's made right at the eve of trial. Usually it's made a couple of days before trial. And these motions in limine are almost exclusively for evidence issues. You want to ask the judge to make an advanced ruling on whether certain evidence will be admitted at the trial. I've had cases as a prosecutor where I made these motions, and it was very clear that if the judge did not rule in my favor, I could not prove my case. And I made that motion. I even tell the judge, listen, Judge, I'm not trying to influence your decision, but I will tell you that the reason why we have to have this motion heard before the trial is because we don't want a trial if you rule against us. And the reason why is because there won't be enough evidence. And so they'll take that very seriously. They'll say, okay, let's hear it now, because I'm not going to go through a whole trial just to later on kick the evidence out and then dismiss the case. Let's just do it now in a few minutes and get it all over with. So these are motions in limine. So anywhere we think there's controversial evidence, that means where the other side is going to say, no, that shouldn't come in, and here's the reasons why. But we say, yes, it should come in, and here's the reasons why. When there's that kind of controversy going on, we better have a motion in limine in which we ask the court to make a ruling on it, because otherwise we're going to go into trial and we have no idea whether we're going to win or not. because we don't know what evidence is going to get on before the jury. And if these are pieces of evidence that may be the only evidence we have that proves the case, if we have one ruling against us, the whole case is over and we lose. All right, there's also suppression. And what this happens is in a criminal case. It doesn't happen in a civil case. It happens in criminal cases, and it's where evidence is perfectly good evidence. It's very relevant evidence. It's often very damning evidence, but it was picked up illegally by the police. And therefore, the courts will suppress it as a way to prevent the police from violating people's constitutional rights, and they'll suppress the evidence. So there's motions to suppress evidence, and those can be made before trial also, so that it could be, for instance, you could take away an entire prosecutor's case because the evidence that they were relying on for the case is not admissible. It's going to be suppressed because courts will not allow in evidence that has been gotten in violation of constitutional rights. Also, there's what we call a limiting instruction. And limiting instruction is where we talked about before, where it was not unethical for us to get evidence in the back door. So evidence may not be admissible for a particular purpose, but then it may be admissible for another purpose. Well, if that's the case, and when we talk the judge into giving us that evidence through the back door for this other purpose, then the court's going to give what's called a limiting instruction to the jury. It's going to say, jury, I'm going to allow this evidence in, but I'm going to only allow you to use it for this particular limited purpose and for no other purpose. So the jury now has to, at least in theory, has to use the evidence for only one purpose, that is the legitimate purpose, and may not use it to prove anything else. Well, and unfortunately that the juries don't do such a great job of that, and that's why we still try to get the evidence in anyway so the jury can see it, because maybe it will influence them in ways that they don't understand. And I know that doesn't make any sense, but it's not unethical, because if we can get the evidence in and a judge says it's admissible through our arguments, then it's legitimate evidence. All right, that's it for the first chapter. It's basically an overview of many of the most fundamental aspects of evidence, both in terms of what it is, how it's classified, how it's collected, and the mechanisms that we have to collect it, and then how we sort of make sure that we have a pretty good idea what kind of evidence we're going to get in at trial before we actually go to trial. All right, so that's the end of chapter 1. Again, if you have any questions, feel free to give me a call, and I'll be more than glad to help.